At the time, post-war reforms were underway in Japan. Behind the scenes, those who led Japan during World War II were put on trial. This was the International Military Tribunal, commonly known as the Tokyo Trial. The trial lasted for about 2.5 years. 6 soldiers and 1 civilian were sentenced to death by hanging. 16 others were sentenced to life imprisonment. What kind of trial was this that marked the end of the Empire of Japan? After the end of World War II, Douglas MacArthur General arrived in Japan. His first order was to arrest Hideki Tojo and name other war criminal. The Potsdam Declaration, which Japan accepted when it surrendered, included the following words: "But stern justice shall be meted out to all war criminals, including those who have visited cruelties upon our prisoners." Based on this statement, GHQ began identifying and arresting suspects in order to punish war crimes. First, it seemed that Hideki Tojo's arrest would go smoothly because he was at home and not fleeing or hiding. The question was who to name as war criminal. Having just arrived in Japan, GHQ had little knowledge of Japanese politics or the organizational structure of the Army and Navy. They were unsure who to name as war criminal. So they came up with this idea. If Hideki Tojo was the first war criminal, then surely the ministers who served in his cabinet should also be considered war criminal? It was a simple idea. Thus, GHQ carried out the first round of designations of war criminal, primarily consisting of ministers from the Tojo cabinet. As the investigation continued, the number of war criminal increased. In addition to the first round of war criminal designations, a second and third round were also carried out. Of these war criminal, the first to be arrested was, of course, Hideki Tojo. He once instructed Japanese soldiers to choose death with honor rather than suffer the humiliation of being a prisoner of war. He believed that he should die honorably, in accordance with what he had taught them. However, he was also deeply concerned that the Emperor of Japan might be held responsible for the war. He felt that this was something that had to be avoided at all costs. Should I choose to commit suicide like a Japanese soldier? Should I choose to go to court to deny the Emperor of Japan's war responsibility? He was struggling with this. Under these circumstances, the US military suddenly showed up at his home and attempted to arrest him. At that point, he finally committed suicide by shooting himself in the heart with a handgun. However, the attempt failed. Because he was unable to die, people said this to him. He didn't really intend to die. His suicide attempt is a travesty. He's an army general, but he doesn't even seem to know how to shoot a gun. He was harshly criticized in this way. After that, having once prepared himself for death, he resolved to face trial. He decided to deny the Emperor of Japan's responsibility in court and put all the blame on himself. Seeing this arrest spree, the Japanese government was surprised that GHQ had suddenly begun arresting war criminal. The Japanese government quickly asserted to the Allies that Japan will carry out the punishment of war crimes on its own initiative. However, the Allies responded, Japan may detain and extradite war criminal, but not hold trials. From then on, the Japanese government began to arrest and extradite war criminal based on the list of suspects received from GHQ. However, some people turned themselves in. Others committed suicide before they could be arrested. The crimes of those detained were broadly classified into 3 types. The first category was crimes against peace, including planning, preparing, initiating, and waging war of aggression. The second category was war crimes, which involved violations of conventions established under the traditional international laws of war. The third category was crimes against humanity, including massacres and violence committed by military forces against civilians. Suspected war criminals were referred to as Class A war criminals A, Class B war criminals, or Class C war criminals to identify which of these 3 categories their crimes fell under. However, in practice it was difficult to distinguish between Class B and Class C. For this reason, they were often dealt with collectively as Class B and C war criminal. At the Tokyo trial, which I will be discussing today, some of the more than 100 Class A war criminals were tried. It was a representative group of 28 people who played an integral role in planning the Japanese invasion. They were imprisoned in Sugamo Prison, which was run by the US military. From there they were to appear in court. In this way, former Japanese leaders were named as suspects of war criminal. And the issue that arose was, of course, the Emperor of Japan's responsibility for the war. This was an issue of preservation of the national polity that the Japanese government was concerned about at the end of the war. Naturally, the Japanese government's policy in the trial was to prove that the Emperor of Japan was not responsible for the war. However, some allies were of the opinion that the Emperor of Japan's war responsibility should be pursued. The United States, which had a strong voice in the occupation of Japan, was unsure what to do about the issue. The United States sent a secret notice to Douglas MacArthur General, urging him to quickly gather evidence showing that the Emperor of Japan was responsible for the war. But when he received this notice, he thought, "We can use the Emperor of Japan to smoothly carry out the occupation. Therefore, the pursuit of war responsibility against the Emperor of Japan must be avoided somehow." Therefore, he conveyed to Chief of Staff Eisenhower in Washington his view that the Emperor of Japan would not be prosecuted as a war criminal. No evidence has been found to show that the Emperor of Japan was responsible for the war. The Emperor of Japan is a symbol of the unity of the Japanese people. Destroying it will lead to the disintegration of Japan. And the Japanese believe that the Potsdam Declaration will ensure the survival of the Emperor of Japan system. If the Emperor of Japan is tried, the Japanese people will see it as a betrayal. If that happens, the Japanese people will continue to harbor anger and hatred toward the Allies. And Japan will resist the occupation policy, and chaos will result. After the Allied forces withdraw, there will be a greater likelihood of communist activity. To prevent this, we would need at least 1 million troops, hundreds of thousands of civil servants, and a wartime supply system. Therefore, the existence of the Emperor of Japan is necessary for the purpose of controlling the occupation and preventing communism. He argued as follows. Thus, the United States solidified its policy of not prosecuting the Emperor of Japan. The Tokyo trial began amidst this chaos of intentions. The Tokyo trial were held at the former Imperial Japanese Army Academy Ichigaya. During the war, the site housed the Army Ministry, the General Staff, and the Imperial General Headquarters, Army Section. I'll tell you a little about the characters in the Tokyo trial. First of all, a defendant is someone who is accused of a crime and is on trial. At the Tokyo trial, Japan's wartime leaders, such as Hideki Tojo, were brought to justice as defendants. Next, the defense attorney. The defense attorney represents the defendant and argues for acquittal or a reduced sentence. To ensure fairness in the trial, defendants must have a lawyer. But these lawyers were primarily the defendant's trusted friends, family members, wartime colleagues, and subordinates. They did not necessarily have legal knowledge or trial experience. Naturally, this puts the defendant at a disadvantage. Therefore, the Japanese government has asked the US government to add several dozen American lawyers to the defense team. The defendant was initially wary of his American lawyer. However, the defendant was impressed by their dedication and gradually began to trust them. In contrast, there are people called prosecutors. The prosecutor's role is to use evidence to prove that the defendant is guilty and to present the case to the court. At the Tokyo trial, one prosecutor participated from each of the 11 Allies nations. The person in charge of coordinating the whole thing was Joseph B. Keenan, chief prosecutor, from the United States. And judges and magistrates are the ones who conduct trials and make final decisions. Like the prosecutors, one judge was sent from each of the 11 Allies, and they all discussed the case together and reached a conclusion. William Webb, presiding judge, an Australian, played a central role among them. Now you should have some understanding of the characters who appeared at the Tokyo trial. Next, I will give you an overview of the Tokyo trial. First, there is a plea to the charges arraignment process in which the defendant answers whether or not he or she admits to the charges. The prosecution then uses evidence to prove the guilt of the defendants. The defense then presents evidence to the contrary. Then, the prosecution's closing argument and the defense closing argument will be presented. Finally, the judges At plea to the charges arraignment, the defendants were informed of the charges. The indictment was read out, detailing what the defendant did, when, where and what crime it constituted. However, from day one, laughter often broke out in the courtroom. This was because one of the defendants was Shumei Okawa, who looked decidedly strange, wearing pajamas and Geta sandals. He was once called the Greater East Asia debater and the theoretical pillar of the revolutionary young officers. He shook Japan as the theoretical leader of the May 15th incident and the February 26th incident. As he sat in the dock, he scratched his head, bowed his head, and at times clasped his hands together for long periods of time. Eventually, he started acting noticeably strange, with his nose running and not even bothering to wipe it. He hit Hideki Tojo over the head, who was sitting in the seat in front of him. So people finally burst out laughing. It was a scene that didn't resemble a trial. The next day, William Webb presiding judge ordered him to undergo a psychiatric evaluation. He was sent to hospital and then deemed unfit for trial and removed from the hearing. In addition, Asami Nagano and Yosuke Matsuoka died of illness during the trial. Therefore, they were also removed from the group of defendants. This brought the total number of people being tried to 25. After the indictment was read out, Ichiro Kiyase, the deputy head of the defense team, suddenly submitted an emergency motion. William Webb presiding judge is from Australia. He is already investigating atrocities and murders committed by the Japanese military at the request of the Australian government. He is therefore unfit to preside over this court. He insisted. It was an unexpected turn of events, so William Webb presiding judge forced a recess. He declared in the resumed court that the motion is denied because the court has no power to remove its own members. Then the scheduled plea to the charges arraignment began. However, Ichiro Kiyase continued to point out problems with the Tokyo trial and submit motion. Germany and Japan have different ways of surrender. Germany resisted to the end and Hitler died. But Japan is different. Japan accepted the Potsdam Declaration before the Allied forces landed on the Japanese mainland. Therefore, it would be wrong to simply apply the trials that took place in Germany to Japan. Crimes against peace, crimes against humanity are ex post facto law. Accordingly, the Allies have no jurisdiction to try the defendants on those charges. He made this assertive claim. Joseph B. Keenan, chief prosecutor, said, "The victorious nations deserve to be able to punish those responsible for the war of aggression. Japan has unconditional surrender," he countered. However, William Webb presiding judge and the other judges were unable to provide an immediate answer to these questions. In the end, William Webb presiding judge let the situation go by saying, "All motion are denied and the reasons for this will be communicated at a future date." However, these issues are still being debated among scholars, and no definitive conclusions have been reached. The plea to the charges arraignment. However, the Tokyo trial proceeded with many legal and ethical issues still remaining. Thus, the trial proceeded to the prosecution stage. The content was roughly divided into 10 stages. The prosecution established a chronological crimes against peace. It all began with the Huangqin incident, which marked the start of Japan's full-scale invasion of China. Various pieces of evidence and witnesses gradually revealed the course of Japan's war of aggression. Many Japanese people learned these facts for the first time. The Japanese people were deeply shocked by the atrocities committed by the Japanese military, such as the Nanjing Massacre, the Bataan Death March, and the mistreatment and execution of prisoners of war. The prosecution's case lasted for more than 6 months. Once all evidence was presented, the defense filed a motion to dismiss all charges. However, this motion was also rejected. The trial then proceeded to the rebuttal evidence or argument defense stage. The content was roughly divided into 6 stages. The defense also used evidence and witnesses to refute the prosecution's case. The defense argued as follows. International law does not hold individuals responsible for the actions of their states. Japan's leaders have no intention of conquering the world together with Germany and Italy. Even the loss of life caused by war is now being considered murder. The defense also argued against China. If a local solution had been reached during the Manchurian incident, as Japan hoped, the situation would not have escalated. Furthermore, the defense argued against the Soviet Union. The Soviet Union is rehashing an issue that has already been resolved. On the contrary, the Soviet Union violated the Soviet-Japanese Neutrality Pact. The defense countered that the United States applied pressure and intimidation and restricted oil exports. William Webb presiding judge rejected evidence that seemed both damaging to the prosecution and favorable to the defendant. The attitude and stance of most judges was close to the prosecution's side. Under such difficult circumstances, the defense fought hard to refute the case. However, during the defense's rebuttal stage, the Emperor of Japan's war responsibility, rather than personal issues, attracted the most attention. The United States had already made up its mind not to hold the Emperor of Japan responsible for the war. This intention was also privately conveyed to Joseph B. Keenan, chief prosecutor. However, the difficult thing about this trial was that 11 of the Allies were involved. Judges in the Soviet Union and China insisted on having the Emperor of Japan appear before the court. International relations with those countries also had a strong influence on the trial. Therefore, Joseph B. Keenan, chief prosecutor, had to get the defendants to say, "The Emperor of Japan was not responsible for the war, I was responsible." He had this hidden mission. The person who was perfect for this was Hideki Tojo. With this in mind, the United States contacted him on multiple occasions. The United States asked the Japanese side to prove that the Emperor of Japan was innocent and to testify that Emperor of Japan had reluctantly given his approval to the war. The United States also hoped that Hideki Tojo would take full responsibility and die to protect the Emperor of Japan. This was in line with the direction he was heading. This led to a strange partnership between him and the United States. However, something unexpected happened here. Koichi Kido's lawyer asked Hideki Tojo the following question. Has Koichi Kido ever acted against the Emperor of Japan's desire for peace? To which he replied, of course there are no such cases. It is impossible for a subject of Japan to do anything against His Majesty's will, he asserted. He was determined to take full responsibility and die, so he shielded the other defendants as much as possible. However, it was a mistake for him to protect Koichi Kido. This is because his statement that the subjects of Japan will not go against the will of the Emperor of Japan could be interpreted as meaning that the decision to go to war was also the Emperor of Japan's will. Joseph B. Keenan, chief prosecutor, turned pale when he heard him say this. However, when the court took a break, he immediately contacted Hideki Tojo and made him promise to retract his earlier testimony. Later in court, he asked Hideki Tojo, "Was what you said a few days ago correct?" Hideki Tojo responded, "I was simply expressing my feelings as a citizen, and that is separate from the issue of the Emperor of Japan's war responsibility." With that, the situation was resolved. Thus, the prosecution's evidence and the defense's rebuttal were completed, and the Tokyo trial reached its climax. After closing arguments and closing statements, a long recess began. The judges wrote their judgments during that time. Thus ended the long-running Tokyo trial. Australian William Webb presiding judge sentenced all 25 defendants to prison. 6 military personnel and 1 civilian were hanged, and 16 were sentenced to life imprisonment. Mamoru Shigemitsu was sentenced to 7 years in prison, and Shigenori Togo to 20 years. However, the judgment that was read at that time was what is called a majority judgment. It was not a ruling that was unanimously agreed upon by the justices. There were disagreements among the 11 justices. There were also minority justices who submitted their own opinions and rulings. Particular attention was paid to Radhabinod Pal, Judge Pal, representing India. He wrote a longer and more extensive opinion than the majority opinion. He delivered the minority opinion acquitting all defendants. Nevertheless, the day of execution came. They died at the execution site set up inside Sugamo prison, shouting "Long live the Emperor of Japan" 3 times just before their execution. The site of the gallows where they died is now a park. Even today, many people visit there,